بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على نبينا محمد وعلى آله وصحبه أجمعين ومن اتبعهم بإحسان إلى يوم الدين. We start in the name of Allah, the Lord of Mercy, the Giver of Mercy. And all praise is due to Allah, the Lord of all beings, and peace and salutations on our Prophet Muhammad and his family and his companions, and all those who follow them in righteousness until the day of reckoning. And with that we begin. So now this is our second session, and there's a lot to discuss in this particular session. This particular session is on the categorization of laws. What are the categories of laws? What do we mean by that? Because it's quite a general question. These are categories pertaining to laws themselves in terms of how they relate to people, meaning whether the laws themselves are obligatory, recommended, prohibited, and things like this. So that's one aspect of the categorization. And the other aspect of the categorization as well is the categorization of laws in terms of the laws themselves and how they relate to the validity of the laws. So, for example, what's a cause of an obligatory action? What is a requirement of an obligatory action, and things like this? So, terms like shart and suburb and things like this, mani', as we'll cover very shortly. These are a different types. These all fall under the different categorizations known as Ahkam Wad'i. So you've got Ahkam Taklifiyyah, which is things like obligation, based permissibility, discouragement, and things like that. And then you've got Ahkam Wad'i, which relate to, what's the difference between the two? The second, Ahkam Wad'i, they relate to the actions themselves. And this will become a lot clearer when we get into the slides. And so, the categories of laws. So, Hukm Wad'i. I believe there should be a slide. Okay, yeah. This particular slide was a sort of a reminder for us that we're covering Usul al-Fiqh, the book of al-Judai. And so what we'll find throughout the lessons is that we'll be covering topics according to the order found within the book itself. And that's why we're covering this particular topic, Ahkam Taklifiyyah and Ahkam Wad'iyah. What we mentioned last week about the purpose of Usul al-Fiqh as well, and we mentioned that the purpose of Usul al-Fiqh is that it ought to be practical. Now there's a question here about Ahkam Taklifiyyah and Ahkam Wad'iyah, in terms of whether or not they're practical or whether they're mere theory. And so, and you also have this discussion for the chapter of Ifta and the chapter of Ijtihad and the requirements of Ijtihad, that is that actually practical, or is that technically something outside the study of Usul al-Fiqh? Because it's not really the principles of how to understand texts themselves. However, these are still important topics, and they still you typically find them in works of Usul al-Fiqh, and they help you conceptualize laws, right, which are also important in terms of how you understand how you understand the hierarchy of laws in terms of a bird's eye view, essentially. And so this is still really important to understanding law, even if it might not necessarily be important to how to understand texts. Although, as we'll get to very shortly, there's a particular point I'm going to mention about anachronistic readings of texts in light of these categorizations, right? We'll get into that shortly. But anyway, let's start with Hukm Wad'i. So Hukm Wad'i, as we mentioned, they are rulings as they relate to the action action itself rather than the person. And what we mean by that is we're not talking about an action being obligatory or discouraged, because these things relate to the person themselves and whether it's obligatory on the person, right? That's Ahkam Taklifiyyah. They're obligatory on the person, or they're recommended for the person, or they're discouraged for the person. Hukm Wad'i is different. Hukm Wad'i relates to the action itself and the validity of the action. right? That's essentially what Hukm Wad'i is. And so you have these terms that require explaining. Sheikh Judai goes in a lot more detail, and he mentions several examples, right? But I think I'll sort of I'll just capture the base term and I'll give an example accordingly. And so one of the terms you have here is sabab. Sabab, Hukm Wad'i, for the term sabab. And a sabab is a cause for an action being the way that it is. So in this case, in this example, the entry of Ramadan is a sabab, it's a cause for the obligation of Ramadan. And so it's a Hukm Wad'i in terms of it being a ruling that pertains to the action, and its validity. Then you also have the term shart, which is a condition, meaning the condition for the validity of the action itself. And so an example of this would be purity for prayer, right? Purity for prayer, meaning you can only perform the salah if you have wudu or ghusl, right? Accordingly. And then you have the third, which is a mani', preventative, meaning this is the thing which, if found, it prevents the action from being valid. And an example of this is menstruation for the prayer. So during the state of menstruation, of course, the prayer is invalid. And so the menstruation itself, the hayd, is considered a mani'. Another example of this, and this is a contemporary example, right? And I thought, I try to also bring examples that are relevant to us as well, because, it makes these things more personal. And so, there's a contemporary discussion on children born outside of wedlock. And so here there's a discussion here that, okay, if a children, typically in a marriage, when there's a child, the child is attributed to the parents, right? It's attributed to the parents, of course. And you also have a relevant hadith to this, which is al-waladu lil-firash, that the child is attributed to it belongs to the bed, essentially. Firash meaning the bedding, and scholars disagree on what exactly that means. What does firash literally mean here? But essentially it means that the child is attributed to the parents and the bed that they share, because they typically sleep together. That's arguably one interpretation. And so so that's typically the case. The child is attributed to the parents. But now you have a question that if a child is born outside of wedlock, the child is attributed to the mother, but is the child also attributed to the father? And so scholars, they disagree on this. And so those scholars who said classically, those scholars who said that the child is not attributed to the father, they would say that zina, the fornication, is a mani', is a preventative for this particular ascription, right? And those other scholars that say that no, the child can still be attributed to the father, they say that no, it's not a mani'. It's not a mani'. And you have scholars in the past that held that view. And you also have many contemporaries that also hold that view. And it's a relevant discussion today because, it's of significant consequence. Because, if you highlight or identify the father of a child, right, that's also relevant to the rights of the child and whether you have the nafaqah, the expenditure and things like this taken care of by the father. And so, it's a consequential example. And so, that's one of these examples for the mani', the preventative. Right, and also and then finally you also have, or not finally, you have some more, but you also have the term sihha, and this relates to the validity of the action, the validity and soundness of the action itself. And the validity and soundness of an action ultimately goes back to the first 3 points, the sabab, shart and mani'. That if the cause is found, if the cause for the obligation is found, and all the shurut, the conditions are fulfilled, and there are no preventatives, there's no mawani', then the action itself is valid. You see, so it relates back to the first thing. And there's also a discussion here in terms of sihha, because sihha relates to validity and soundness, but it can also, but an action can also be valid while being corrupt. While it can be valid while being corrupt. And this ultimately goes down to what I've mentioned here, that actions have essential components to them. And then you have other things that are the quality of those essential components. And so what typically happens is, if you have the essential components all ticked off, then the action itself is valid. Action itself is valid, but it can still be corrupt if the quality of the action is not complete. It's not, optimal, right? And so, for example, if you have a trade, if you have a transaction, right? And the offer and acceptance is fulfilled, so that these are the essential components of that transaction, and so the transaction itself is valid. But then the quality of the action can pertain to external things. So there might be an extrinsic prohibition, or there might be some form of deception, and then you've got scholarly discussion on that. Okay, does that relate to, how exactly does that tie into validity and the corruption of the contract itself? But these are also important questions. And here, when you explain things like this, now you understand, okay, this is a relevant discussion for Usul al-Fiqh, in the sense that it helps you not only conceptualize rulings, but also piece rulings together. And so that's siha. Now you also have things that relate to the second term, the condition, right? The condition, which is the condition for the validity of an action. Now you have a question here, that what's the difference between a shart and a rukn? Because you always find these two terms in books of law as well. And so what you have here is, you have the difference between shart and rukn. And so the shart pertains to the condition of an action, right? And they're both requirements. So the shart is the condition of an action, and the rukn is the integral of the action itself. And the difference, the primary difference between the two is that the condition is something external to the action itself, while the rukn is part of the action itself. You see, and so an example of this that scholars sometimes discuss is the takbiratul ihram in salah, the initial takbir. Is that a condition for the action, or is that an integral? Now, practically, it's inconsequential in the sense that you have to do both anyway. So they're both requirements. So whether it's a shart or a rukn, you have to do them. But it's the way you conceptualize the action itself, in terms of a condition being something external and a rukn being the part of the action itself. And so that's another part of Hukm Wad'i. Now we get into a very interesting discussion, right? An interesting discussion, which is that you have these two terms, which are also part of Hukm Wad'i, things that relate to the action itself. And these two terms are ada and qada. And so what's the difference between these two terms? Now, ada, is performing an action, is usually an act of worship. So for example, salah, this is typically used for things like salah, and performing the prayer in time or outside of the time. So ada, technically, these are all technical terminology, right? And so, you have the terminology of ada, which is performing an action within the appointed time. So performing salah, for example, within the appointed time. And qada is performing an action outside the appointed time. Now, both of these relate to the time of fulfillment of the action itself, right? And so these two are also distinctions, but they're distinctions in terminology. Why is this important? Right? No. How are these terms actually used in revelation? Right? Because one thing that you'd find, even with the Ahkam Taklifiyyah, one of the problems that people face when it comes to the Ahkam Taklifiyyah, right? A very big problem, right, is that they always conflate terminology, technical terms, and linguistic terms. All these terms that we're mentioning here, whether it's Ahkam Wad'iyah or Ahkam Taklifiyyah, like wajib, sunnah, makruh, and ada, qada, all these terms as described here and defined here are all technical terms. They're all technical terms used by jurists in this technical way, in this with these juristic definitions after the time of revelation. So after the time the Quran was revealed, and after the time of the Prophet sallallahu alaihi wasallam. Meaning what? Meaning that if you were to read Revelation and you see the word ada and qada and sunnah and makruh, don't immediately assume that qada means qada with this in this technical definition, because it doesn't. It's not used that way. It's anachronistic to read it that way. The same thing with sunnah. You can't simply look at a hadith that has the word sunnah and immediately say, okay, now it fits neatly into this category of sunnah in, like, according to how jurists use the term. That's not how revelation uses the term. Revelation simply uses it linguistically. And all these terms, they come after revelation. Yeah. And so imposing these terms on revelation and the Quran and Hadith would lead necessarily to you misunderstanding what's actually being said. Right. And in this light, we have this quote by Ibn Taymiyyah. And this is one of his quotes, right? And you also have something very similar by Imam Ibn Hajar. So this is Imam Ibn Taymiyyah, and you have got Ibn Hajar as well, who also discusses this. And so he mentions over here, and he's just discussing qada and ada. So he says, فَإِنْ قِيلْ هَذَا يُسَمَّى قَضَاء أو أَدَاء. Like, this particular thing that's being discussed, is it termed qada or ada? Right? And so he responds, he says, قِيلْ الْفَرْقُ بَيْنَ اللَّفْظَيْنِ هُوَ فَرْقٌ إِصْطِلَاحِي. That the distinction between qada and ada is simply a technical distinction that you're making. It's simply a technical distinction that you're making, a juristic definition. لا أصل له في كلام الله ورسوله. Meaning, this isn't to say you can't use them terms. That's not what Ibn Taymiyyah is saying here, right? And that's not what other scholars who mention the same point are saying here. They're simply saying that, look, acknowledge the juristic technical term and acknowledge the linguistic term, you see? The linguistic term. And so you have and so Ibn Taymiyyah, he continues and he says لا أصل له, like, this technical usage لا أصل له في كلام الله ورسوله فإن الله تعالى سمى فعل العبادة في وقتها قضاء. Right? That this particular usage isn't found in Revelation. Why? Because and Allah Most High, he also labels an action that's performed within its time as qada. What's an example of that? كما قال في الجمعة فإذا قضيت الصلاة فانتشروا. فإذا قضيت الصلاة, when the salah in this is in Surah Jumu'ah, when the salah is completed, when it's fulfilled, then disperse and spread out in the land. Over here, the term isn't used in the technical term as the salah being performed outside of its appointed time. And another example, وقال تعالى فإذا قضيتم مناسككم فاذكروا الله. This is in the context of Hajj, that when you fulfill your Hajj rights, then remember God. So this isn't saying like when you fulfill the rights outside of its time. مع أن هذين يفعلان في الوقت. That these things, they're done within the time. And then he explains how they're used within Revelation itself. So he says والقضاء في لغة العرب هو, what is it? هو إكمال الشيء وإتمامه. It simply means completing something. That's all it means. كما قال تعالى فقضاهن سبع سماوات أي أكملهن وأتمهن. That just as Allah Most High says regarding the seven heavens, that He basically completed them, meaning He completed the creation. Then he, Ibn Taymiyyah, he ends by saying فمن فعل العبادة كاملة فقد قضاها وإن فعلها في وقتها. So therefore, technically, linguistically speaking, if someone performs an action completely, even within its time, then he's technically done qada of it, linguistically. And this is also relevant. What's an example of this? And where does this actually have consequence in Revelation? There's the famous hadith where the Prophet ﷺ, he says that referring to the context of missing raka'at behind the imam. So someone comes behind the imam, he's performing salah, the Prophet and he misses like one or two rak'ahs, let's say, right? So what does the Prophet ﷺ say? He says, like, join the prayer, essentially, perform the salah, and whatever you miss, in some wordings, what does he say? He says, do qada of it. Do qada of it. He uses the term qada, and in other wordings, he says he uses the term itmam. Now, some scholars, when they looked at this hadith, and they looked at this hadith, right? And they looked at qada here in terms of the technical meaning of making something up, right? And so and so what does Ibn Taymiyyah say there as well? And Ibn Hajar mentions the same thing there, right? They say that, look, qada in that hadith is not referring to making up the prayer. And how is it consequential in that hadith? Someone might ask. It's consequential because there's a question amongst jurists that the units that you missed with the imam, when you make them up, are those units the first raka'at that you missed, or is it the first raka'at of the salah, or is it the final raka'at of the salah? In other words, when you're joining the imam and you've come in late, are the raka'at that you catch with the imam the beginning of the prayer or the end of the prayer, right? And that has consequences. I mean, like, it has, like, what's the juristic consequence of that? It's the consequences when you make up the prayer. If it's the beginning of the prayer, then you treat it, you behave like, you recite like a chapter along with the Fatiha, right? Because it's the beginning of the prayer. But if it's the end of the prayer, then you don't necessarily have to do that. You see, you can miss the chapter out, after the Fatiha. So you suffice with the Fatiha, and so that's where the discussion lies. But that discussion, but irrespective of irrespective of the argument supporting either view, right? The point here is what? The point here is that in that hadith that we just discussed, which uses the word qada and itmam, one can't make the argument that qada is used according to the technical term of qada, right? Of making up something, right? It's simply in the linguistic usage. Linguistic term meaning to complete something. Wa ikmalu shay wa itmam, as Ibn Taymiyyah mentions here. And this is one example from qada and ada, but we're also going to get to this in some of the other examples as well with the Ahkam Taklifiyyah, because this is also consequential there. Right? Particularly with the hadith, man raghiba an sunnati falaysa minni, the very popular hadith, that whoever sort of turns away from my sunnah is not from me. Now, what does sunnah mean here? It doesn't mean the technical juristic category of sunnah being something that's recommended. No. It means a tariqa, a way or a path, as we'll get to shortly, inshallah. So that's, this is the technical usage of qada and ada, and the linguistic usage in revelation. In revelation, it's used linguistically. Now we have a question also on the ada and qada issue. And this is an issue that this is from Sheikh Abdullah al-Judai's book, right? So Sheikh Judai, his book on Usul al-Fiqh. So what does he say here? There's a question here. Okay, we know that you have actions that are instructed. So for example, we have salawat that are instructed on all the believers to fulfill. And then, but the question is, okay, if someone fails to fulfill the instruction of the initial instruction of fulfilling the salah within its appointed time, then is there a requirement to have a separate instruction and a separate legislation for qada, for making the prayer up? In other words, another way to look at this is, what's the actual instruction in it, when Allah Most High, when He gives the instruction of fulfilling the prayer? Is the requirement to simply get the act fulfilled? Is that the primary purpose, to simply get the act fulfilled, whether it's within its time or outside its time? And if someone misses it within its time, then he's sinned, and he must still make it up within or outside the time. So it's still within the initial instruction of fulfilling the prayer. Or if someone misses the prayer within its appointed time, is a separate instruction required? For its obligation? And you know what, before I get to this slide, let's go on to the next slide. This is for some clarification. So i.e., is the action itself intended, whether it's in the appointed time or outside the appointed time, while there's an obligation to perform it within its obligatory time? Or is the action within its appointed time intended? And so if you've missed it out, if you've missed the time, then you haven't fulfilled the instruction, and it's not included within the initial instruction to perform the action within the time. And so, there's an example here that I've given. So, here's an example. Imagine there's a teacher, and the teacher sets homework for the pupils, right? So you've got this, and the teacher says, okay, I want this particular homework in by Friday. And so what happens is, one of the students, he doesn't do the homework, right? He doesn't do the homework for Friday. Now the question here is that homework still due in the next week on Monday, or is it not? In other words, is it included within the initial instruction by the teacher to hand in the homework by Friday? Or does there require a separate instruction by the teacher saying, okay, you've missed it now, I want it in next week? right? So, that's basically the question. This is a real life example too, and the same concept applies, right? And so I've mentioned a few things here. Which can influence the way you might respond, because ultimately it's down to these different arguments. So someone might ask, okay, the way you'd actually determine whether the homework is still due in after Friday is, one of the things you'd ask yourself is the context one of tutoring? Meaning, like, if it's is the homework itself considered an opportunity for the student, which is likelier in the context of tutoring, where people are actively taking their time out, their spare time out to study, and that's an opportunity? Or is is it a context of, where the homework is likely to be seen as a burden, like in a school setting, for example, right? And so, why is that the case? Because someone might say that if the homework, if it's a punishment on this particular student for not handing the homework in, that if the goal is to punish the student, then the teacher might still demand that the homework be given in the next week, you see. But in a context of tutoring, where the homework isn't seen as a burden but rather an opportunity, they actively want to give the homework, now the punishment might be seen differently. Now the punishment might be, okay, you didn't hand it in, I set a deadline, you've basically, you're at loss, essentially. And so, someone might consider the context in terms of, determining the answer. Or if the teacher says, next time I want it handed in on time. Now this, of course, this particular statement can be applied to homeworks in the future. Like, this is a principle by the teacher that usually this is the expectation. And so you can apply the same thing in the future. Or previous occurrences, again, same concept. Or the passing of time. What do I mean by that? Is like, okay, someone hasn't given in their homework, and then a few weeks go past and they still haven't given it in, and the teacher doesn't say anything. Now that's an indication that the teacher wasn't expecting the homework, you see. And then another qara'in. These are all like qara'in and arguments that you can make, right? And another argument here is incomplete homework essentially piling on. What do I mean by this? Like, let's just say a teacher has assigned 5 different homeworks over a few months, and this particular student, he's never done them. Now, is it likely for the teacher to say, okay, I want every single one of those homeworks in due next week, or like, over the next month? Or would the teacher look at that and say, like, hang on a minute, it's a bit impractical for me to demand all of those homework, or all that homework. Rather, I'm just going to say, fulfill the next assignment that I give you. And so, these are all arguments that you're making. Now, how does this relate to revelation? How does this relate to revelation, you might ask? We get into that now. And so, and what's the popular example here? The popular example is performing salah on time. So we know, okay, there's an instruction to perform salah on time. Now, there's a question amongst jurists as well, though like many people aren't aware of this, but there's a discussion amongst jurists as well, that is it also an obligation for someone who intentionally misses the prayer to perform the prayer outside of the time, or to perform the prayer? So he's missed the prayer, maybe he's missed it for years. Now, is he still required to perform qada of all those salah prayers that he's missed? Essentially, that's the question. That's how it's relevant here. And this, of course, this is just one angle. This is just one angle of addressing this juristic question, right? This isn't a comprehensive discussion on the issue, right? And remember, we discussed this last lesson as well, that in Usul al-Fiqh, remember that juristic cases, they're mostly built on several arguments. They're not simply built on one argument. And so here, like whenever you come across an example in Usul al-Fiqh works, look at it from that perspective. The goal of the example is to simply understand the example in light of the principle that's mentioned. That's it. It's not to make an ultimate. It's not to gain a conclusion on the topic as though you've exhausted the issue. No. Right, and so that's important. So now we get into the reading. So what does Sheikh Abdullah al-Judai say? He says that, okay, يتصل بالحكم الوضعي مسميات شرعية ثلاثة كلها أوصاف للعبادة باعتبار الوقت الذي تؤدى فيه. So you have 3 different categories also related to Hukm Wad'i, right? These actions, and in relation to the time in which they're fulfilled. And so what's the first? Al-ada, and the second is qada, as we've explained previously. And so he says, وجدير بالتنبيه عليه هنا أن القضاء لم يرد في نصوص الشرع إلا في إيقاع الإبادة بعد خروج وقتها بعذر كالنوم عن الصلاة أو الصوم للحائض أو النفساء. So he says, Sheikh Abdullah al-Judai, he argues here that in Revelation or in Hadiths, the only time you find qada mentioned or instructed as a separate legislation, is only when there's a particular excuse that the person has for missing the action. So for example, you've got the famous hadith of the Prophet ﷺ that whoever basically sleeps or forgets the prayer, then he should perform the prayer when he remembers or when he's basically wakes up, right? And so, that's with an udhr, you've got an excuse there, right? Or another excuse is fasting, making up the fast while in the state of menstruation, you see? And so, that's also an excuse. And then he says, أما خروج الوقت بدون عذر فلم يرد فيه القضاء بخلاف الذي عليه كثير من الفقهاء. Now, as an explicit text, as an explicit text, you don't find a separate legislation for qada for qada of a particular action when missed without an excuse. That's basically what he's arguing. Now this is sound, right? What you're saying here is sound, but again, remember, this is only addressing one angle of this question that's going to arise regarding qada, salah, and things like this. So what does he say? He continues. He says, وَيُؤَكِّدُ ذَلِكَ وَيُؤَيِّدُهُ مَسْأَلَةٌ أَثَارَهَا الْأُصُولِيُّونَ. Here, هل القضاء يكون بالأمر الأول الذي كان به الأداء أو يحتاج إلى أمر جديد? So now here's a question that arises that we've just mentioned before. Does qada require a separate legislation or a separate instruction, or is it included within the initial instruction, right, to fulfill the action? Now, what does Sheikh Abdullah al-Judai say? He says, جمهورهم, according to the majority, أنه يحتاج إلى أمر جديد, that he actually requires a separate legislation. So it requires a separate instruction. وهذا هو الصواب. This is, the correct view according to Sheikh Abdullah al-Judai. And then he continues, فإن العبادة المعلقة بوقت إنما مقصود الشرع أن تقع في الوقت الذي حدده لها. Meaning, why is this the case? Because the purpose of actions that relate to a particular time frame, an appointed time, is that they be fulfilled within that specific time frame. And this is, of course, you can sort of look at this as a consequence of that law rather than an argument for the law itself. Because again, like going back to the teacher example, it really depends on the case at hand. And then, he continues, فإذا أخل المكلف بذلك فأداها خارج وقتها بدون عذر فلم يقع فعله لها كما أمر. وقد قال النبي صلى الله عليه وسلم من عمل عملا ليس عليه أمرنا فهو رد. And then, that's what we mentioned earlier. And then he continues and he says, وهذا بخلاف المعذور. And this, what we're mentioning here is contrary, is different to the person who has an excuse, who's missed the action or the act of worship with an excuse. فهو إما أن تكون الشريعة أسقطت عنه القضاء فلم تأمره به كما في قضاء الصلاة للحائض، وإما أن تكون أمرته به بأمر جديد كصلاة النائم والناس وقضاء الصوم للحائض والنفساء والمريض والمسافر وقضاء الحج عمن عجز عنه في حياته. And so, this is contrary to someone who misses the act with an excuse, because you have two possibilities that you find, or you have two scenarios that you typically find from hadiths. One is that the Sharia completely drops the obligation of the act of worship itself, like qada of salah during menstruation. That's not required to be made up. Or what does the Sharia do? It actually gives a separate legislation and instruction to perform the action when there's an excuse, like someone who's sleeping and or forgets the prayer, as we mentioned before. And then he says, right? And then, he says, what's the consequence of that? وَيَتَفَرَّعُ عَنْ هَذَا مَسْأَلَةٌ مَشْهُورَةٌ. You have a famous question, famous legal issue that arises from this entire discussion, which is what we mentioned before. وهي قضاء الصلاة والصوم ونحوهما لمن ترك أداء ذلك في وقته متعمدا. Someone who intentionally leaves the prayer and the fast. He intentionally leaves it within the time. فهذا what this is Sheikh Abdullah al-Judai's position, right? What does he say? He argues فهذا ليس له رخصة في القضاء إنما سبيله التوبة النصوح وأن يكثر من التطوع. So he argues that his view on this topic is that this person can't, like, he can't perform qada, right? He can't perform qada, but rather he repents and he makes abundant voluntary he performs abundant voluntary actions, right? Like, voluntary prayers and things like this. Now this is Sheikh Abdullah al-Judai's view, and again, this is simply one angle of addressing this. You have several arguments both for and against this position that goes beyond this mere question, right? And you have things like you have things like qiyas that's discussed at length on this particular issue. You have several arguments on both sides, right? And what he's mentioned here is a view. This is the view held classically by some of the Hanabila and some of the Shafi'is. And you have other scholars as well, like Ibn Hazm, of course, he's a Zahiri scholar. He argues this. Al-Izz ibn Abd salam, he mentions this. He mentions an argument for this position in his Al-Qawaid al-Kubra. You've got Ibn Taymiyyah as well, who argues for this. I believe Ibn al-Qayyim as well. Ibn Rajab, he has a lengthy discussion on this in the Fath al-Bari. In his Fath al-Bari, his commentary on Bukhari is also called Fath al-Bari, just like Ibn Hajar. And so he also has a discussion on this, and he inclines, though he doesn't state this explicitly, but he inclines to a very similar position to this. But my goal here isn't to really get into the issue itself, right? I'm just explaining the example as it relates to the usuli principle that's mentioned here. Does qada require a separate instruction or does it not? That's it. And so here, as Sheikh Abdullah Judai has mentioned, he's mentioned that you have three categories for acts of worship and their performance within the appointed time. You have the first category being ada, the second being qada, and the third is the one he mentions here, al-i'ada, which is to repeat the prayer. وهي إيقاع العبادة في وقتها بعد تقدم إيقاعها على خلل في الأجزاء كإنقاص ركن أو شرط. So this is basically repeating the prayer that you've already performed because there was some deficiency within the prayer itself. And so, that's just another way of categorizing this particular issue. And so, that's the question of, does qada require a separate instruction or not? Ultimately, in the same way that we mentioned this example of the teacher and the homework, ultimately it goes down to different arguments that you have and different qara'in. Like, remember, each legal case is looked at in a unique way. Each legal case is unique. And so just as, the answer won't be the same with the teacher and the homework, similarly, even with legal cases, you might not necessarily have the same answer for every single issue pertaining to ada and qada, right? And so, but that's an important discussion. And I believe Ibn Rushd in Bidayatul Mujtahid, he also mentions this issue when discussing the same legal case of qada of salah. Right, so he mentions the same thing, so you can have a look at that if you wish. But that's does qada require a separate instruction or not? And ultimately it goes back to whether the action itself is intended or whether the action within the appointed time is what's required. Now we have, so that we've covered most of the Ahkam Wad'i. Now we just have two left, which is azima and rukhsah. And these are popular terms. You might have come across this. So the distinction between azima and rukhsah is that azima refers to the default expectation of a legislation, or the default ruling. That's not linked to exceptional circumstances. Rukhsah, on the other hand, they're concessions, and they're linked to exceptional circumstances. What we mean by exceptional circumstances in Arabic, they refer to it as awarid, basically, exceptional circumstances. And so an example of this was this will make it a lot clearer, shortening the prayer while traveling. And so shortening the prayer is a concession, it's a rukhsah, right? It's a rukhsah, and so and it's only applicable while the person is traveling, and so it's an exceptional circumstance. But under default circumstances, ordinary circumstances, what's the default expectation? The azima itself, it's performing the prayer in full. So that's the distinction. You also have other examples, of course, other examples like consuming pork. Consuming pork, that's prohibited. So the default expectation is prohibition and abstinence from the action itself. The concession is in the circumstance of necessity, when you're in a circumstance where you're potentially going to die. And so it's permitted then, right? So that's a concession. That's another example. And so what are reasons for these concessions? Because concessions, they ultimately go back to this concept and idea of ease in law. And so you have several reasons that you find within law that creates these concessions. And so, one of them is illness. So for example, an example of this is when someone is ill, they have a choice. They don't have to perform the fast in Ramadan, right? So that's a reason. It ultimately goes back to ease. Same thing with traveling. We mentioned shortening the prayer. Same thing with those scholars who argue that you can combine the prayer, combine Dhuhr and Asr and combine Maghrib and Isha. Ultimately, that goes back to ease. Forgetfulness as well. Forgetfulness, an example of this is someone forgetting that he's fasting in Ramadan and he consumes food or drink. Then, a group of scholars, a large group of scholars based on the Hadith, they say that, okay, the fast is not invalid. It's not invalidated through that. Why? Because it's due to forgetfulness. Another example is coercion, that someone forces you to do something, then that you have concessions pertaining to that. Common conception is uttering words of disbelief when you're coerced to do so, and this ultimately goes back to the Quranic verse where Allah Most High, he says illa man ukriha wa qalbuhu mutma'innun bil iman. That what's the coercion, this particular exception relates to those who are coerced. They're forced to utter these words. Wa qalbuhu mutma'innun bil iman. Their heart is content with faith. So they really believe these are just words that they're uttering because they're forced to do so. And so that's another reason. And another example of that could also relate to cases of statements of divorce. Statements of divorce when someone's forced to utter those words. Though there's obviously scholarly discussion on that. And ultimately, the last one, and all these concepts as well, they go back to this idea of difficulty and ease. So difficulty, and a common example of this would be the notion of umum al-balwa. And umum al-balwa, this particular term, we'll get into this in a future lesson as well, but it's used in one of two ways. And people often get confused on this point as well. Umum al-balwa is used in one of two ways. It can be used in this context, which is that when it's difficult to avoid something that's unlawful, or difficult to avoid something like impurity. And so, a concession is typically made in these circumstances because it's impractical or it's difficult to avoid like impurity, for example, right? And so you have umum al-balwa, this particular term, used in this context in this way, that is difficult, there's widespread difficulty essentially. Then the other way of using umum al-balwa is in the context of transmission. It's in the context of transmission, which is when there's an expectation for something to be transmitted. Umum al-balwa in the sense that there's widespread pertinence and relevance to the people such that you expect it to be transmitted. And this particular concept is very, very important. It's not simply a Hanafi concept that some people assume. It's not it's not a strict Hanafi concept. It's applicable even by the Malikis, as we'll get to, even with Amal Ahl al-Madina, right? As Ibn Rushd argues. It's applicable there. They're using the same concept. Even the Muhaddithun, even scholars of Hadith, the condition of authenticity of shudud, adamu shudud, that this particular condition, of course there's details on how to exactly understand this condition, but one of the ways to understand it ultimately goes back to this idea of umum al-balwa. And that's there's a separate that's a separate discussion, but the muhaddithun also incorporate this principle within their framework, and this principle is also very important in the topic of ijma'. In the topic of ijma', unfortunately, people overlook that, right? But it's also a concept, a very, very important concept a concept that we apply in our everyday life, right? And we'll discuss that in a future lesson. But just note here that you have two ways of using the term umum al-balwa. Here it's used in a very specific way, which is avoiding difficulty, essentially, right? And so, these are reasons for ease. And here's another point. These rukhas that are mentioned here, right? When we say rukhsah over here, these rukhas, these concessions, they're concessions that are ascribed and prescribed by Allah Most High. Meaning, Allah Most High in the Quran, or you have the hadiths by the Prophet sallallahu alaihi wasallam, they're the ones who have prescribed these concessions. And this is very different. This is important to note because you also have the term rukhsah mentioned in the context of scholarly differences. Scholarly differences. And that's a different context. And there's, of course, a discussion for that as well. But when we mention rukhsah over here, we mean those that are actively prescribed by Allah Most High. And so, there's a particular hadith where the Prophet sallallahu alaihi wasallam says that Allah Most High, He loves for His rukhas to be adopted, right? He loves for His rukhas to be adopted, just as He likes basically the default rulings to be adopted. But now rukhas in that hadith, it doesn't refer to scholarly differences. It refers to those prescribed by Allah Most High. So, for example, Allah Most High, He's allowed you to choose not to fast while you're traveling. Yeah, right. So that's a particular rukhsah, a concession that Allah Most High has given you, and so He likes for that particular concession to be adopted by you, just as He likes the default expectations to be adopted, indicating that the religion is one of ease, and the legislations are one of ease as well. These are legislations of ease by Allah Most High, and this idea of ease within the law itself is mentioned numerous times in the Quran and Hadith. Numerous times, يريد الله بكم اليسر ولا يريد بكم العسر. God Most High, He intends ease for you. He doesn't intend difficulty. لا يكلف الله نفسا إلا وسعها. Allah does not burden a soul beyond its capacity. وما جعل عليكم في الدين من حرج. He has not placed upon you any difficulty. يريد الله أن يخفف عنكم وخلق الإنسان ضعيفا. Allah Most High, He wants things to be light on you, and man has been created weak, right? يريد الله أن يخفف ما يريد الله ما يريد الله ليجعل عليكم من حرج ولكن يريد ليطهركم. In the context of tayammum, that Allah Most High wants this lightening and ease for you, right? He doesn't want difficulty on you. He simply wants to have you purify yourself. That's it. And so and these are the several Quranic verses. You have other Quranic verses as well, and you have hadiths as well on this particular topic. But ultimately, this concept goes back to the rukhas within the law itself. And so these are the Ahkam Wad'i that we've covered. Now we'll get into the Ahkam Taklifiyyah. We get into the Ahkam Taklifiyyah now, and this is, as we mentioned, the introductory slide, just to remind ourselves about the book and the order that we're going to be covering the lessons in. Okay, now we get into the categories of laws, and again, this is the same thing. This is just like a precursor for getting into the Ahkam Taklifiyyah, just a reminder. So now we have two ways of categorizing laws, right? So one is the Hukm Wad'i, as we've just mentioned. It's a ruling assigned by God in the way that these things relate to the action and its validity. So the focus is on the action itself, as we've explained. Things like sabab, shart, ada, and qada. These are all things that pertain to the action itself. Then you have Hukm Taklifi, which is a ruling assigned by God as well, in the way it relates to those morally responsible, those mukallaf. You see, meaning, is it obligatory? Is it recommended? Is it permissible? Is it discouraged? Is it unlawful? So these particular questions, these rulings, these are known as the Ahkam Taklifiyyah. And what you'll notice here as well, this is important as well, that both these things, in the definition, what's mentioned is that these are rulings assigned by God. These are rulings assigned by God, Allah Most High. In other words, you're attributing these things, you're attributing these rulings, these whether it's recommendation or discouragement or prohibition, you're ascribing all of these things to Allah Most High. And that's important because it helps you understand that juristic activity, when scholars are engaging in law and they come to conclusions, this is risky activity by its very nature, because all of this activity pertains to attributing things to Allah Most High, which is why Ibn al-Qayyim, for example, he has the work إعلام الموقعين إعلام الموقعين عن رب العالمين, essentially. That those people who are signing off things in the name of the Lord of the entire universe and all people within it, you see. And that's a very difficult station to really internalize. But this is important. Why? Because it indicates that when you assign particular rulings to particular categories, you ought to have some caution with respect to that. And so now we get into the Ahkam Taklifiyyah. And with the Ahkam Taklifiyyah, this is a bird's eye view initially, right? First, we come to the bird's eye view, which is that you have 5 categories for the Ahkam Taklifiyyah. So you have the wajib, those things that are obligatory. Then you have the mandu, those things that are mandub or sunnah, thing, right, recommended. Then you have mubah, base permissibility, makruh, discouraged, and haram, prohibited. Now, just a brief rundown of what these are, but we'll get into the definitions later, or in the following slides. For wajib, this is something that's obligatory, something that you must do, i.e. you're sinful for not doing it, and you're rewarded for doing it because you're fulfilling the command and instruction. And those things that are recommended, you're not sinful for abstaining from them, but you're rewarded for doing them. Mubah is base permissibility. This refers to things that are simply neutral. Things that are simply neutral. So for example, sleeping, eating, things like this. These are base permissible and neutral actions. You're not rewarded for them inherently, nor are you sinful for doing them or even leaving them out. Right? These things are simply like they're up to you. They're just left to you. And then you have things that are discouraged, right? Being things that that you're rewarded for abstaining from, right? And but you're not sinful for actively doing. And then you have things that are prohibited, which are things that you're sinful for carrying out, and you're rewarded for abstaining from. And so these are the different categories. These are the different categories. Now, these 5 categories, these are accepted by every single person. Every single person accepts these. This is something to mention before we get into the next points. Why? Because these 5 categories, they're simply the rational way to categorize rulings in terms of their obligatory and prohibitive nature. There's no other way meaning this categorization covers all bases, right? All bases, all angles, essentially is covering all angles. And so all scholars would agree with this. Now, what they do differ on are subcategories. So now, what do we mean by that? Now, you have the Hanafi categorization of this, where they bring about additional categories. So what do they say? They make a distinction generally between fard and wajib. And so they say, okay, the distinction is wajib is something that's obligatory through probabilistic evidences, dhanni evidences, essentially. And fard is something that's obligatory by way of conclusive, decisive evidences, right? The prohibition of pork, for example. Right, and so they make a distinction between. They make a distinction here. However, both of these they're subsumed within the broader category of wajib anyway, the category of obligatory actions. You see, and so this is simply a subcategory. And then another example is karahatu tanzih and karahatu tahrim. Now, what's the distinction here? You have 2 types of discouragement. One type of discouragement is a lighter form of discouragement in the way that we defined and explained above. Makruh, discouraged. In the way we described it there, that it's not sinful for actively performing the action, that's karahatu tanzih. It's a light punishment, a light discouragement. Then you have karahatu tahrim, which is a prohibitive discouragement, meaning this is a subcategory of the category 5. Those actions are prohibited. Now, this is a subcategory, right? And what's the distinction between karahatu tahrim and haram? Exactly the same distinction between fard and wajib. That the distinction is only in terms of the evidences, whether the evidences are conclusive or whether they're not. If they're conclusive, then you use the term haram. If they're not, then you use the term karahatu tahrim. That's the Hanafi categorization of this. Now here's a question. Do other scholars in reality disagree on this? Do other scholars in reality disagree on this? Now people often get confused here, right? And Ahkam Taklifiyyah, usually, like, you know, there's a lot of confusion in this chapter. But one of the ways people get confused is that they assume, okay, yeah, this is a Hanafi categorization, and so like only Hanafis look at rulings in this way. No, every single scholar accepts this difference in principle. But this categorization is only a difference in terminology. That's it. It's a distinction in terminology and how you categorize rulings. Otherwise, every scholar agrees that some things are prohibited through conclusive evidences, and other things are prohibited through probabilistic evidences. And some things are obligatory through probabilistic evidences, and other things are obligatory through probabilistic evidences. And so, like, everyone agrees in principle on all these categories and the way you conceptualize them. They only differ in the terminology. And so where is this where does this actually have some consequence? It has some consequence, particularly when scholars use these terms. So for example, if they label something makruh, so they say yukrahu, X, Y, and Z. So it's disliked or is discouraged to perform this particular action. Now, for the Hanafis, one might ask, all right, is it karahatu tanzih or karahatu tahrim, right? And there's there's discussion there that, okay, which category does it typically fall under? And with the other schools as well, it's interesting, because even with the other schools, even with Imam Shafi'i and Imam Ahmad, when they're using the terms karahah, the question still arises that is it karahatu tanzih or is it karahatu tahrim? That is it, like which category does it fall under? And this ultimately goes back to what we just mentioned before, that when you assign a ruling to any of these categories, you're speaking on behalf of God. And so if you're speaking on behalf of Allah Most High, you're going to be cautious in the way you express yourself. And so even if something is prohibited, you're going to naturally use the term makruh, discouraged, because you're trying to be cautious. You're trying to attribute the prohibition to yourself rather than God, because you're somewhat unsure. Someone's asking you the question, and you're responding, of course, from your perspective, but you're being cautious in your language. And so just naturally, you're going to use terms like karahah and yukrah and makruh, even if it's for prohibitions. And in this light as well, you have the quote by Imam Abu Yusuf. Imam Abu Yusuf, he has a quote in Ar-Rad ala Siyar al-Awza'i. So he's discussing a particular mas'ala, right, a particular legal issue that Imam al-Awza'i has a view on. And Imam al-Awza'i, on this particular issue, he says, هَذَا حَلَالٌ مِنَ اللَّهِ عَزَّ وَجَلَ. That this particular issue is halal from God. Meaning this is something, I mean, he's very confident in this ascription to Allah Most High. And Imam Abu Yusuf, he responds to this. He says, like, how great is this statement that he's just uttered over here? Like, this is a very grave statement, right? And then he says, what does Imam Abu Yusuf say? He says that what I found from my mashayikh, from my teachers, is that they would not use terms like halal and haram except for things that are in the Quran, bayyinan bila tafsir. That these things, they're clear cut, no need for explanation. In other words, what is he saying? He's saying that halal and haram, people are cautious. The scholars in his time, what he found was that they were very cautious in the way they approach these things, and so they avoided using terms like halal and haram just naturally. And so that's why when you find terms like yukrahu X, Y, and Z by Imam Ahmad and Imam Shafi and other scholars, even Hanafi scholars, you have this discussion, this question arises: is it karahatu tanzih or karahatu tahrim? Generally, what they say about the other three schools, besides the Hanafis, is that the default is karahatu tanzih, and this is what Sheikh Abdullah al-Judai also mentions in the book. That the default is that unless you have reason to believe otherwise. And then for the Hanafis, the default is karahatu tahrim, unless you have reason to believe otherwise. But ultimately, these things come down to looking at the context, looking at the ruling itself, contrasting the different quotes and gathering them all from the scholar, from the scholar. And so, you know, it maybe he's described one thing with discouragement in one place, but elsewhere he's quite explicit that he means tahrim. And sometimes scholars, they disagree on what the Imam himself means. Sometimes they disagree on what the Imam himself means. And it's because of the sort of ambiguity to some degree of the term itself. And so that's important. So Ahkam Taklifiyyah is not simply the categorization that's important, it's also how you interpret and understand the quotes and rulings from scholars in the past, right? And so, you know, and again, everyone in principle agrees on the 5 categories. They disagree only in terminology. And so this is why you also find quotes by scholars from the 3 schools, I believe. So you find some scholars mentioning things like, you know, like everyone agrees on like karahah tanzih and karahah tahrim, and the distinction between fard and wajib, and probabilistic and conclusive evidences, and the distinction between the two. Now we have this question, and you'll probably come across this quite a bit, this term, khilaf al-awla. And khilaf al-awla, what does this mean? Right, this means literally, quite literally, it means something, it's a practice that's contrary to what is best, contrary to what is al-awla, contrary to best practice. That's what this means. Now, is this particular term required in the 5 categories that we just had? Arguably, it's not. Because again, it can fit into one of these categories. In fact, it can fit into either mubah or makruh. And so I don't think, like, you know, having this category as a separate category within the Ahkam Taklifiyyah, I think creates a lot of confusion. And so rather than having it as a separate category within this categorization, I think it's a lot easier to simply look at khilaf al-awla and use it in a linguistic way. So you just look at khilaf al-awla. What does khilaf al-awla mean linguistically? It means contrary to best practice. And so what that means is, you know, that linguistic usage means that you understand it contextually. Because when you're saying that it's contrary to something that's best, you're making a comparative statement. That's a relative statement. This is contrary to what is best, meaning you're comparing 2 things. And so if you're comparing something that's mustahab, recommended, with something that's merely permitted, then the thing that's merely permitted is contrary to what is best in comparison to the 2 choices that you have. And sometimes the 2 choices that you have are like something that's mubah and something that's discouraged. And so the thing that's discouraged will be labeled khilaf al-awla in comparison, you see. And so, like, it's important to understand it this way, because a lot of people, they assume that khilaf al-awla necessarily means makruh. That's not necessarily the case. Why? Because it's also possible that khilaf al-awla can be used for something that's mubah, or not pursuing something that's recommended. And how is it used in that way? Well, if you're not pursuing something that's recommended, and fulfilling the thing that's recommended is recommended, it's, you know, it's something that's encouraged, then for you to not pursue it is doing something that's contrary to best practice. And so you can label that as khilaf al-awla. So it can be mubah or it can be makruh. It doesn't necessarily mean that the act itself is reprehensible. It can simply be mubah, a neutral action. And so this is important, that whenever you see this, you read it like it's easier to simply just read it according to its linguistic usage, and you look at the context, and whether it's mubah or makruh ultimately goes back to the context in which the word is used. But it's important to understand khilaf al-awla is not a separate category to the 5 that we mentioned before, but it's included within mubah or makruh. It's included within mubah and makruh, and you determine that based on the context. This is important to understand, right? This is important to understand. So that's khilaf al-awla, right? Khilaf al-awla. And again, avoid anachronisms. Avoid anachronisms when it comes to how to understand these terms, and sort of imposing certain terms, certain beliefs, or certain definitions that words are basically coupled with, and imposing it on scholars and their statements when they're not using it in that way. Right, when they're not using it in that way. This is very similar to the point that we mentioned before about ada and qada. In Revelation, it's not used in that technical usage, you see. It's used linguistically. And so, this is a point that that's important even for wajib. This avoiding anachronisms, is important for all the Ahkam Taklifiyyah. And so, and we'll give an example for wajib as well. But what is wajib? Before we actually get into the example I'll mention immediately after this definition, wajib is something that's obligatory, and it means that it's encouraged, and so it's required from you by way of obligation, meaning you have to do it. That's what an obligation is. And so you're rewarded for performing the obligatory action, and there's sin and condemnation for abstaining from the action itself. Why? Because it's obligatory. This is simply what it means for something to be obligatory, right? This is simply what it means. And so I'll mention the example for the anachronistic way of understanding wajib after this, actually. So you have different ways of expressing obligation. So the question is, okay, we have this category of wujub, of things that are obligatory, but how do you know whether something is obligatory or not? And this goes down to the different ways obligation is expressed. And so you can have a direct instruction that Allah Most High is simply telling you, do X, Y, or Z. That mere instruction by someone in a position of authority indicates an obligation. Of course, this is one way that instructions are used, because you can also have instructions in the Quran as well, in the Hadith, that on for obligation. And we'll get into this in more detail when we cover instructions, right? Awamir, these instructions, in the chapter of Dalalatul Alfaz. Dalalatul Alfaz, it's more relevant in that chapter, so we'll discuss it there. But sometimes you have instructions and therefore obligations, and sometimes you have instructions and therefore recommendation or otherwise. And so you have different ways of expressing obligation. And so an example is Allah Most High instructing the performance of the prayer. That's an obligation. And then you also have another way of expressing it, which is the term kataba, that in indicating that the action itself is prescribed on you. As Allah Most High says in the Quran regarding fasting, Ya ayyuhalladhina amanu kutiba alaykumus siyam. Kutiba alaykumus siyam. That fasting has been prescribed on you, and this prescription itself indicates obligation. And so that's another way that it's prescribed, that it's an indication of obligation. Related to this as well, you also have the term ala, the preposition ala. Ala means on, meaning like, and when it's used in this way, it's sort of used in the meaning of it's a duty on me to do X, Y, and Z. Very similar to the verse on the Hajj, وَلِلَّهِ عَلَى النَّاسِ حِجُّ الْبَيْتِ, that it's required. What's the duty on people? It's to perform the pilgrimage, the Hajj itself. And so there's the phrase ala there. Another way to express obligation is a description of people, or a description in the context of instruction. What do we mean by that? Imagine, for example, a teacher, and they're setting instructions down. So they're laying instructions, right, to the pupils. And the teacher says, okay, this particular group, these people on the right of the class, they'll come in, they'll do the they'll enter the classroom tomorrow at 2:00, and group 2 will enter the classroom at 3:00. Now that's simply a description. Like, it's just describing, it's a khabar, as you describing in Arabic. It's simply a sentence describing some information. It's just information, that's all it is. But it's in the context of instructing them to do a particular thing. And you also find this in the Quran a number of times. For example, Allah Most High says, وَالَّذِينَ يُتَوَفَّوْنَ مِنْكُمْ وَيَذَرُونَ أَزْوَاجًا يَتَرَبَّصْنَ بِأَرْبَعَةِ أَشْهُرٍ وَعَشْرًا. Those basically people in the context of those who are widows, those who leave their spouses, right? Those who pass away and they leave their spouses will lie in wait, meaning they'll wait in the idda period, the period of waiting, for 4 months and 10 days. And so that's simply a description, that's simply a statement that this is what they'll do. But this is in the context of an instruction, and so that's why you understand that to be an obligation, you see. And so and this is mentioned numerous times in the Quran. And again, this ultimately goes back to dalalatul alfaz. The reason I mentioned the teacher example, and I'm going to do this a lot in the dalalatul alfaz lessons, is that you understand that, okay, this is just naturally how language works. This is naturally how language works. Just as you understand it in English this way, right? You being used in this way, you can also understand it in Arabic. It's used the same way. It's used the same way there. And this will be a lot clearer, hopefully. It'll also make the dalalatul alfaz lessons a lot clearer. And so that's another way of expressing obligation. And then you have another way, the final way, or I say final, this is just part of the list. You have other ways, of course, as well. But another way to indicate obligation is that the action itself is coupled with a threat. And this goes without saying, that if you have a threat coupled with an action, that indicates the strict requirement for the action itself, you see. And so that's another way. Now, we mentioned before about avoiding anachronisms. So I'll just get to that point with the term wajib, right? With the term wajib. So the term wajib in the juristic definition is, as we've explained here, an obligatory action. In Revelation, however, it doesn't necessarily mean that. It doesn't necessarily mean that. Now, where is this relevant? This is relevant in the hadith of bathing on Friday. Allah Most High, he uses the Prophet sallallahu alaihi wasallam. He says, "Ghuslu yawm al-jumu'ah wajibun ala kulli muhtalim." That bathing on Friday is wajib. Is wajib. What exactly does that mean? But we'll get to. But it's wajib on every mature person. And so the term here, wajib, this hadith should not be read like this. It should not be read as, okay, the term wajib is mentioned in the hadith, therefore that in the hadith it directly refers to the juristic definition that jurists categorize the ahkam in. So I'm just going to place it in the category of wajib. That's not how it's being used there. It might, yes, someone might conclude that yes, it belongs in the category of wajib according to the juristic categorization, for sure. But that's not simply because it's being used in that way in the hadith. It's not being used in that way in the hadith. And so this is why, like, scholars, when they approach this hadith, they have two ways of approaching it. So they'll say, okay, wajib, it could mean wajib in terms of obligation, in which case then we'll put it in that particular category of wajib. Or it could mean wajib in the sense that it's a duty for you, indicating an encouragement, or like a firm encouragement. Like, as Imam Shafi'i, when Imam Shafi'i discusses this hadith in Kitab and Kitab al-Risala as well, he mentions, what does he say? He says that you have two ways of looking at this hadith of wajib. You can say wajib in the sense that you must do it, or wajib in the sense that wajib it's a required of you fil ikhtiyar wa fil nadafa and wa fil akhlaq, meaning best practice essentially. And you've got a separate discussion on that among scholars, but you have two ways of approaching that hadith. I mean, one could also argue, and I believe this is a nice way to approach this hadith, which is that yes, it does indicate obligation, right? Bathing on Friday, it does indicate obligation for those, of course, attending the Friday prayer, and that, but then it's linked to the legal cause found in other hadiths. But again, this is sort of zooming into a particular legal case. But the ultimate point that we're making here is, don't have an anachronistic reading of that hadith. غسل يوم الجمعة واجب على كل مسلم, right? That's important. And so now we get into another topic on wajib, and this is an important topic, right? It's an important topic, and it's the principle ما لا يتم الواجب إلا به فهو واجب. That something, an obligatory action that cannot be completed except with another action itself, meaning that action itself becomes obligatory. So you have an obligatory action, and the only way you can fulfill that obligatory action is to perform another action. Now this action itself, it might not have been obligatory, but it becomes obligatory because the thing it leads to is obligatory, you see. So it's obligatory by way of its consequence, because this thing is a requirement, you see. And so that's a principle over here. ما لا يتم الواجب إلا به فهو واجب. Now the question is, how do you understand this principle, and is it prescriptive or is it descriptive? Now we'll get into this. Now Sheikh Abdullah al-Judai's perspective on this is as follows. So he argues, Sheikh Abdullah al-Judai, he says that this particular principle is only applicable when the obligation itself is actively intended. Meaning that you have an obligation. So for example, we've got something mentioned here, purity for salah. So we know salah itself is an obligation. And we know, and purity is a means for salah. But we also know that purity itself in the hadith is actively required. And so this particular principle of ma la yatimul wajibu illa bihi fahuwa wajib is actually just descriptive of this relationship, according to Sheikh Abdullah al-Judai. He's saying that, look, ma la yatimul wajibu illa bihi fahuwa wajib, it's simply describing this relationship, that purity is an obligation in the hadith because it's a requirement for the salah itself. But this isn't prescribing anything. This principle isn't telling you that if there's something that's wajib and you have something else that leads to it, that thing also becomes wajib. Meaning by applying this principle, because this principle isn't intended to be prescriptive, according to Sheikh Abdullah al-Judai. And what do we mean by actively intended here and not conditional? This is in contrast to another example, like, for zakah. Zakah itself is an obligation. And a condition for zakah is the nisab, having the nisab, the minimum threshold. But this nisab is conditional. This nisab isn't actively sought from you as an obligation from the hadiths. And so that's why having the nisab, even though it's a means for the obligation of zakah, right? Having the nisab itself is not an obligation. This is, the way Sheikh Abdullah al-Judai, he presents the mas'ala, this particular principle. He actually, when he was presenting this principle, he actually categorizes it in three ways. And I think it's just a lot easier to present it this way. I think it sort of gets confusing when you mention three categories and you say that, okay, ma la yatimul wajibu illa bihi fahuwa wajib is only applicable to the third and not the first two. Instead, I think you should just, it's easier to just drop the first two categories and say when it's applicable. And so that anything that doesn't fulfill, what this category that I've mentioned here and the way I've described it is not applicable. I think it's a lot easier to just, it's not applicable to the principle. Yeah, it's just a lot easier to present it like that. But anyway, this is Sheikh Abdullah al-Judai's view on this. However, I think there is an argument to say that the principle itself is descriptive. The principle itself is descriptive. But the thing is, the way this is applied is sort of on a case-by-case basis. It's contextual, you see. It's contextual. And we know it's contextual because of the zakah and the nisab example that we just gave. That sometimes you have, zakah is an obligation, but getting the nisab is not an obligation. Why? Because it's not actively intended. So we know ma la yatimul wajibu illa bihi fahuwa wajib is not unrestricted. You see, it's not unrestricted. And so this particular principle is to be applied on a case-by-case basis ultimately, and it's a principle that's built on consequences. Because if the obligation itself is something that's actively intended from you, it's actively sought out for you to get to, it's like a goal for you to get to, then anything that leads to that obligation, just rationally, I think, should also be a requirement for that. And an example of this, a contemporary example again, we mentioned a similar example for the mani, a contemporary example for mani and the zina, whether the zina is a preventative for ascribing the lineage. Now you have another example on the same topic, or on a similar topic, which is DNA tests. So you have a contemporary discussion on the use of DNA tests and ascribing the lineage of children to their parents by way of DNA tests. Now we know, and so the question is, are DNA tests an obligation before ascribing the lineage? So if you're able to take a DNA test to achieve a great degree of certainty that the child is attributed to the parent, to this man, then is that a requirement or not? Is that a requirement or not? Similarly, you have a discussion on the hadith, the fiqh chapter of li'an, li'an. For those who are familiar with that, you have the chapter of li'an. The question is DNA tests a condition before allowing people to engage in li'an? So I won't get into li'an because I think we'll get into a bigger discussion. But that's a question. Are DNA tests required for the ascription of lineages? And so we know from the Sharia that the goal of the Sharia is to have sound ascriptions of lineages. And so if we know that that's a goal, then DNA tests fulfill that goal. And so DNA tests arguably are also a requirement to fulfill that goal. As per مَا لَا يَتِمُّ الْوَاجِبُ إِلَّا بِهِ فَهُوَ وَاجِبٌ. And that having a sound lineage is something that's actively sought out by the Sharia. It's not simply a conditional obligation. It's something that's actively sought out by the Sharia. And so that's why the DNA tests here would be would arguably be a requirement there. And this is something that Dr. Ayman Saleh he's got a work on DNA tests as well, and the use of DNA tests, and this is what he argues in that book as well. And of course it makes sense. And he also appeals to this principle there as well. مَا لَا يَتِمُّ الْوَاجِبُ إِلَّا بِهِ فَهُوَ وَاجِبٌ. He appeals to that principle there as well. Now another aspect to this principle as well, and this is important, right? This is important, and I'll couple this with an example. Is that this principle is applicable when there's only one avenue to fulfill the obligation. So someone can only make an argument that a particular action is an obligation because it leads to another obligation, right? As per مَا لَا يَتِمُّ الْوَاجِبُ إِلَّا بِهِ فَهُوَ وَاجِبٌ. If that's the only way to fulfill this obligation. Otherwise, if you have multiple avenues, then you can't single out this single avenue to say that, okay, you must do this particular action to fulfill the obligation, because someone can respond by saying, hang on a minute, I can also do it this way and that way and that way and that way. In the same way, if I were to say, getting fit, you have to play football to get fit. Now someone will say, like, what are you talking about? Like, football is simply one exercise that I can possibly do. I can also engage in other sport activities or even other fitness activities to better my fitness. And so it's like that. Like, why are you specifying football there? That's just one option that I have. So here too, when you have an obligation and you have multiple ways of fulfilling that obligation, then you can't specify any single avenue to be obligatory. And this is important. Why? Because this is pertinent to this is a claim that I've heard before as well, and I'm sure the person also appealed to this principle. This مَا لَا يَتِمُّ الْوَاجِبُ إِلَّا بِهِ فَهُوَ وَاجِبٌ. And the appeal was, what was the claim? The claim was having a sort of a spiritual mentor and pledging allegiance to that particular mentor is a requirement because purifying yourself, your inner self from spiritual diseases or spiritual ills and harmful traits is an obligation, of course, and that's obviously clear. That's an obligation, and that therefore, because this is a means to get to that, having a spiritual mentor, then this too must be an obligation. You see, and this is something that Sheikh Abdul Fattah Abu Ghudda, he also discusses in his book Risalatul Mustarshidin. Now, this particular argument, it doesn't work under this principle. For a number of reasons. One is, the simple fact that this isn't the only avenue to fulfill the obligation, firstly. And secondly, this particular, if this were an obligation, then the requirement for this obligation was also pertinent and relevant in the time of revelation and the centuries that came after, and no jurist actually spoke on this, or even anyone speaking on this matter of removing ill traits and evil traits within oneself, that no one actually obligated that. And so even though the same circumstances that we have were present there, you see. And so Sheikh Abdul Fattah Abu Ghudda, when he's discussing this, he says that he also quotes a classical scholar on this topic. And that classical scholar, what does he say? He says that, look, this particular requirement of having a spiritual mentor in this way, in this way, like a formalized way, this is only found in later works, It's not found in earlier works, even like works of like Aqutul Qulub by Abu Talib al-Makki. Like you don't find it there indicating that they didn't consider it an obligation. Even though someone could say ma la yatimul wajibu illa bihi fahuwa wajib could have equally been applicable there. Now the only reason I mention this is simply because otherwise, like, I'd be going on a tangent, and like, that's not really what I want to do. Like, I'm just like mentioning this as an example to see how to understand this principle and how exactly this principle works. How exactly does it work, and the things you have to consider before applying it if you're going to apply it and view it in a prescriptive way rather than descriptive. And so that's this something that I thought I'd mention. And so now we get into Sunnah. I think we'll cover this. We'll cover Sunnah, and then we'll get into Mubah next week, inshallah. So Sunnah. Hold on, I'm sort of in two minds. You know what? We'll complete Sunnah. We'll actually complete Sunnah next week, inshallah. Yeah, we'll complete Sunnah next week because I think I've got a few slides on this as well. I think there's a lot to discuss on Sunnah in particular. There's also a Sunnah on there's a famous discussion, or a very important discussion, on Sunnah Mu'akkada, and whether leaving a Sunnah Mu'akkada is an inherent and intrinsic act of sin or not. Is it a sinful act, or is it not? And that's a long discussion, and it's a very important discussion because it's very consequential to how people encourage others to perform actions, like in terms of their da'wah, essentially how they invite people. Because if you believe that missing Sunnah Mu'akkada is a sin, then that also influences whether you're going to make that a top priority at the very beginning when you're preaching to someone, for example, who doesn't perform the prayer to begin with. And so, like, you have consequences on that, and that's a long discussion. So inshallah we'll discuss that next week. So Sunnah Mu'akkada, and also the grades of recommendation and things like that. So inshallah we'll discuss Sunnah next week. We've got a few things to discuss, even from a few quotes by Ibn Daqiq. So inshallah we'll discuss that there. Even the category of mubah, there's a lot to discuss on that as well. So inshallah we'll discuss that next week. Okay, there's a question here about فَمَنْ تَمَتَّعَ بِالْعُمْرَةِ, whether the technical term is used there as well. Yeah, so that's a good example. So so that particular, that you have a difference of opinion over there regarding the term tamattu'. The term tamattu', yeah. So yeah, you would look at that linguistically rather than a particular technical definition for tamattu' that arose later. That'd be the way you read that. Okay. Yeah, someone has their hand. Okay, you should be able to unmute yourself. Assalamu alaikum.
Walaikum assalam. Can you hear me?
I think my mic's off. Hold on, just give me a second. Hello?
Yeah, can you hear me now?
I can hear you now, yeah.
Okay. I had a few questions. Let's see, the first one. It's about what Sheikh Judai was saying about Allah and it requiring its own instruction. I said he mentions that the majority take this rule about that qada requires a separate instruction. But then we were going into the example of salah, right? And we were saying that although we didn't actually talk about it, but we were saying that qiyas could be an example of that kind of instruction, right? So my thought was that if qiyas can be included in the kind of instruction that's required for us to say that there's a qada, doesn't that mean that pretty much in every case there's like automatically an instruction there, kind of making this rule a bit superfluous?
Yeah, I think that would be relevant if there is qiyas on that issue. The question is, I mean, the question that a jurist would ask is there an actual qiyas? You see, because there's not, like, you won't always have qiyas on an issue, firstly. And the second thing as well, even on the issue of qada of salah, like, the example that's mentioned there, even like there are multiple ways to do qiyas there. There are multiple ways to do qiyas. So that's like another question that arises. And so like Ibn Rushd, for example, when he discusses this in Bidayatul Mujtahid, he actually explains that, look, you can look at this, if you're approaching this by way of qiyas, right, this particular mas'ala, you can approach it in one of two ways. You can approach it in one of two ways, and then he details that. And so like, so yes, sometimes you can also have a qiyas, but the question is, okay, but you might have multiple forms of qiyas. And so, like, how is this principle? How would this principle be relevant there? It'd be relevant perhaps if a jury says, "Hang on a minute, let's go by the default ruling. Let's go by, let's approach this step by step. So let's say this particular qiyas is actually in conformity with this principle that we have about a qada requiring a separate instruction. That would be like an additional argument for them to hold that view. You see, when you're choosing between multiple forms of qiyas. And so, like, that's why I also say that juristic arguments, they're all unique. Which is interesting as well, because, like, Sheikh Abdullah al-Judai, when he mentions that principle, he says that the jumhur, the majority, adopt that principle. That's what he argues. Like, whether that ascription is sound or not is a separate discussion. But even if it, like, but the reason I mention that is because if it is sound, that here in this particular mas'ala, it didn't translate to the majority holding the same conclusion that Sheikh Abdullah al-Judai and several classical scholars in the past held. You see, and so, like, that also indicates that it's like this juristic this particular mas'ala, you approach it in terms of, all right, what are the several arguments for this side and what are the several arguments for this other conclusion, and then you sort of stack them up and then you make an assessment accordingly. So yeah, that's that's what I'd say there.
Okay. I had a second question.
For sure, yeah.
Well, and a third one. So it was so we mentioned there were five Ahkam Taklifiyyah that are agreed upon or used by everybody, and then there's a few other subcategorizations or distinctions that can be made by some, but everyone agrees in concept with those further categorizations. It's just whether they adopt the terminology or not. So my question is, why don't they all just adopt this kind of terminology that maybe has a bit more nuance within it?
That's a good question. Now, I think this ultimately goes down to how terminology even come about, because there's a particular process. Like, you have several steps before a term actually becomes like its own distinct terminology, a technical term. And this is something that, for example, like Sheikh Hatim al-Auni in his al-Manhaj al-Muqtarah, this is something that he discusses there for Mustalah al-Hadith. You have the same thing that's mentioned there. And I think it's extremely important to understand the stages between a term being used in its linguistic sense and then eventually becoming the technical term. And so, that's the first thing. So, like, someone could pretty much say that like, scholars, because they didn't use that term in that way, it didn't eventually become a technical term for those scholars. That's the first thing. But secondly, like, I mean, this to answer your question more directly, I think the reason they probably didn't use that same distinction and categorization was because the 5 categories are sufficient. The 5 categories, they cover all bases. You see, I mean, they cover all angles, and so it's not really required to have subcategories for wajib and fard and karahah tahrim and haram, in the same way, for example, in the same way that you don't have, even in that those five categories, you don't have a separate distinction between grades of sunnah. The grades of sunnah mu'akkada, the emphasized sunnah, and the sunnah ghayr mu'akkada, the unemphasized sunnah. Like those two, technically they're subcategories, but they're sort of looked at distinct as sort of distinct subcategories that fall under the general umbrella of sunnah. And we'll get into this inshallah next week when we cover sunnah. But yeah, in the same way that you have grades of recommendation there and they didn't apply it, I think it's the same reason that, you know, you have grades of obligation and grades of prohibition. Yeah, they didn't apply it as well. So I think it's the same reason.
And finally, towards the end, we were talking about wajib and this principle of if something's required for something else that's wajib, then it itself becomes wajib. And we said that there's this condition that it's only applicable when you're actively intending that wajib action. And we gave the example of zakat. As far as I understood what you were saying, that you know, if somebody hasn't reached a sufficient money to or wealth for zakat to be obligatory on them, then it wouldn't be like we wouldn't go out and say it's wajib now for you to reach that level because you know that's what's required for you to give zakat. But I'm not. It seems to me like that doesn't apply because in this case the zakat isn't wajib in the first place for that person until they've reached that, right?
Yeah, so that's like when I say actively intended, I mean that the ultimate obligation, that's what's actively intended by the Sharia. You see, so meaning it's like a goal. I mean, like what you mentioned is correct, and and what you're ultimately saying is that you have the ultimate goal, which is the zakah itself, but getting into a position that makes zakah an obligation isn't something that's actively intended by the Sharia, and this is why the means, the nisab, i.e. the nisab, to get to the zakah is not an obligation. So when I say that the act is not actively intended, meaning it's not actively pursued by the Sharia for all individuals. That's what I mean by actively intended.
Okay, I see what you mean.
Does anyone have any other questions? Or we can leave it there, inshallah. I think, you know, you have some interesting parts of Ahkam Taklifiyyah. I think majority of them, or like, you know, the really interesting bits, at least the bits that I find really interesting, they pertain to Sunnah and Mubah, those two categories. But we'll cover that more, inshallah, next week. So I guess I'll see you there. And if you have any questions, like usual, feel free to share them. And with that we end. وآخر دعوانا أن الحمد لله رب العالمين. May our final call be all praises due to Allah, the Lord of all beings. Assalamu alaikum.
Assalamu alaikum.